Hi, I'm Emily and I am here with Maya Murphy's attorney, Ephraim J. Fink. Attorney Fink practices at Maya Murphy's Westport, Connecticut office and is admitted to practice law in both Connecticut and New York. My question today for Attorney Fink is, I keep hearing that the court can help resolve my car accident case sooner than having to wait for a jury trial, which has been postponed indefinitely due to COVID-19. How can I get my case settled using the court without a trial?
Thank you, Emily. The timing of this question is definitely suitable right now because the word out of the Connecticut judiciary is that all jury trials are suspended without further notice. And the rumor is that trials may not resume until 2021. And even then, a lot of people believe that many jurors may not want to show up to the courthouse. Typically in Connecticut, personal injury cases are resolved one of two ways, by trial or settlement. And while those two options certainly remain viable and are still the most popular methods of disposition, many personal injury claims now are resolved by either binding arbitration or mediation. Trials can become expensive, and choosing alternative dispute resolution options can save money on court costs and legal fees. When you are faced with arbitration or mediation, personal injury plaintiffs often ask, well, what are the difference between the two, and what is the best method for resolving my case? Every personal injury lawsuit is different, of course, but an experienced attorney can evaluate the facts and offer skilled legal guidance as to which alternative dispute resolution method is most suitable for your particular case. So first, I'd like to talk about mediation. Mediation has become a cornerstone alternative dispute resolution method for allowing personal injury cases to resolve by way of settlement. In fact, many litigants and attorneys find that mediation is the most effective means of resolving personal injury cases. Now, sometimes mediation is court-ordered, and the mediator is appointed by the judge. However, mediation is mostly agreed upon by the parties, and that can occur at any time. When it is held in such a private manner, it's called private mediation, the mediator will require a fee. It's usually a few $1,000s, and the parties split those costs. Oftentimes, the mediator is a retired judge or an attorney who is familiar with the area of law at issue or the types of resolutions that are typically seen occurring as a result of solving and settling those types of cases. The mediator essentially serves as a one-person judge and jury. He or she will hear the facts as presented by each side, and they will attempt to facilitate a proposed disposition by presenting an actual settlement figure, or at least a range of settlement in which the mediator thinks the plaintiff and the defendant should meet to resolve their case. When you go to these private mediations, the best way I can describe it is almost semi-formal. You dress up as if you were going to court, but it is not on the record. There is no court reporter or stenographer taking down what everyone has to say. Most of the times, at the beginning and the end, the mediator will meet with everyone all together, and you will get a chance and an opportunity to be heard and hear the other side. But sometimes the mediator also breaks out the parties into different rooms, which is called private caucusing. And the purpose for that is actually for the mediator to play both parties against each other to see if they can find that way of getting to yes and meeting in the middle at a reasonable settlement range. The Connecticut Superior Court system also offers their own judicial alternative dispute resolution. It's called JADR. And that provides half and full day sessions with a judge, and either an active judge in the Superior Courthouse or a retired one, for settlement sessions. And it comes at no cost to either party except for your time. An optimal time to conduct such a session is usually near the end of the case during the pretrial phase. Even though mediation can occur at any time, you want the opportunity for each party to gather enough information to make your liability and damage arguments known, and to present your best position, the position that you would take at trial, presumably, in an effort to resolve the case before having to go pick a jury and go to trial. A judicial ADR session is not intended to delay the progress of the case in any way or interfere with scheduled events like jury selection and trial. If the mediation fails, the parties can go to trial, as they will usually have already had their dates ready to go anyway. Parties and their attorneys are expected to take part in mediation in good faith and make an effort to resolve outstanding issues and potentially settle the entire case. The way it works in Connecticut JADR is you fill out a request form and both parties list judges that they would find amenable to use for mediation. And then the parties are sent a notice with the date, time, and location of the session. The mediator or judge usually has some type of procedural requirements, and what that usually means is you have to submit a mediation statement before the settlement conference, and it's going to contain your version of the facts and your legal arguments and what you think the case is worth. They may also request copies of pleadings or motions and discovery responses and the like, so that they can brief themselves and catch up on what the case is all about. The sessions are usually held in a confidential manner. It's not discussed outside of that. And then if the mediation is not accepted by the parties, if the recommendation is not accepted, you're not stuck with it. You can go on to trial, as we discussed earlier. If in the event that each party is happy with the mediator's recommendation, it can be a much speedier and effective method to resolving a personal injury case that may not see a jury trial for years. Mediation is normally voluntary and not binding. That's the key. Okay. Now I would like to discuss with you arbitration. It used to be that arbitration was used for contractual and business disputes, but has become more and more popular as an alternative to resolve personal injury matters as well. Arbitration is usually more involved and complicated than mediation. Parties can use arbitration in two ways. They can use it at the end of a case, like a trial, after they have gathered and conducted all of their discovery, or they can use arbitration for the entire process. That would mean the pleadings and discovery period with the rules and the scope of discovery are set by the arbitrator. In other words, the arbitrator is the court for the process. Now, Connecticut has its own statutory arbitration scheme to resolve smaller personal injury cases. If the parties agree, or the court maintains on its own, that a case likely has a value of $50,000 or less, then the matter can be sent to the arbitration program for a hearing on both liability and damages. However, the decision issued in that program is not binding. If any party is dissatisfied with the award, they can move to have a trial de novo, a trial anew, before a jury in the Superior Court. That is an unusual program because most arbitrations are binding. In arbitrations with higher damages claims, which are usually binding, each party chooses an arbitrator who acts as a judge in the case. The person is typically also a former judge or a current lawyer. When each party chooses an arbitrator, those two arbitrators then choose a third arbitrator to also hear the case, and the three of them form an arbitration panel. Nevertheless, the parties can also agree to a single arbitrator to hear the case instead of the three arbitrator panel. The panel or the single arbitrator then decide the outcome of the case by listening to arguments. They also take evidence like witnesses and documents, and they hold a hearing just like a trial. Usually the arbitrator or the panel is given free rein to determine an award amount, but sometimes the parties can agree on an acceptable minimum and maximum monetary award range. This is called a high-low arbitration, and the panel can award from that. All in all, arbitration can lead to a swift resolution of the case and a fair verdict, avoiding the unpredictability of leaving the decision to a jury. Now, the danger of arbitration, as I described earlier, is that it is usually what we call binding. That means it is overtly difficult to undo it or reverse it or appeal an arbitration award. In a legal sense, the arbitrator has to commit an error so egregious, so bad. I tend to think of the legal equivalent of saying 2 + 2 is 5, that the award cannot stand because it would be endorsing a great injustice. But other than that, mostly arbitration awards stand and cannot be appealed. So accordingly, when you enter into an agreement and consent to the arbitration process, it cannot be taken lightly, especially if the case might still be best presented before a jury on a strategic basis. If you want to know if your case is ready for mediation or arbitration and you need a litigation attorney to talk to you through the process, please contact Maya Murphy today.